Welcome to today's Lunch and Law on bureaucratic lawlessness at the Consumer Financial Protection Bureau. We are delighted to be featuring the law offices of Crystal Moroney today, one of NCLA's clients that is staring down the administrative state and helping us to force constitutional constraints like due process back on rogue federal agencies. I'm delighted to turn the event over to my colleague, Mike DeGrandis, to introduce our guests and the topic for today. Thank you.
Thank you, Mark. Hello, everyone. I would say welcome to Crystal Moroney and Ron Canter. Crystal is President and Managing Officer, is that the right title? Of the law offices of Crystal Moroney in New City, New York, right?
That is correct.
And you have a license to practice law in New York and New Jersey, right?
That is correct.
Now, Ron, your law offices, you have the law offices of Ronald S. Canter,
Yes.
Is that right? And you are in Rockville, Maryland?
That's correct.
And you have licenses to practice law in, let's see if I can remember them all. There's Virginia, Maryland, D.C., Pennsylvania, is that right? And Florida?
Yes.
All right, very good. Ron represents Crystal in the administrative proceeding. Strange phrasing there to say proceedings. That's not really what's going on at the CFPB level. We'll talk about that in a bit. But Ron represents Crystal in that capacity, while we here at NCLA are helping Crystal out in the Southern District of New York. And of course, we'll get into those details later. What I wanted to impress upon you at the start is that because these are ongoing proceedings, we won't be able to get into confidential communications that we've had, anything attorney-client privilege, anything that could implicate attorney mental impressions. Of course, we don't want to go there. And if you have questions at the end, so we're going to proceed with a little bit of an introduction from each one of us. Then we'll get into a discussion about some of the details of Crystal's circumstances. Ron and Crystal will probably share some war stories of dealing with confronting the administrative state. Is war stories too strong of a phrase? No? Okay. All right, good. It's accurate. Share with us some war stories. And then we'll have questions and answers. I mean, don't hold back on your questions. We'll let you know if we can't answer it. We're not being rude, but we want to make sure we don't waive anything accidentally. I think I should start off by introducing NCLA before we get into some of the details in this very important sense. So you probably know, we're a nonprofit, nonpartisan public interest organization. We provide our legal services pro bono. We provide pro bono legal services to Crystal in this case. A lot of what we do, because we are focused on relegating the administrative state to its proper role in the constitutional order of government, a lot of what we can do at times sounds rather antiseptic. We talk about these broad principles. We cite constitutional provisions such as Article 1, Section 1, vesting clause, Article 1, Section 9, we'll talk about that, appropriations clause, that's implicated here, along with Article 2, Section 2, appointments clause, Article 2, Section 3, take care clause, First Amendment, right to petition government for redress of grievances, Fifth Amendment, right to due process. All of that's fine, and obviously it's important, but it seems so abstract. When the reason why we have civil liberties and the purpose of these constitutional provisions is to secure the blessings of our civil liberties, is that the government, when it operates outside those bounds, tends to step on some toes. And in fact, it tends to be a lot worse. It intentionally does things that will violate your civil liberties. And it's a very real danger to real people. It has real consequences. Not just these abstract notions of those are my civil liberties, but rather, no, this is my profession. This affects me and it affects my family. And so we're going to talk to a real person here today. Crystal, you're a real person, right?
Yes, I am.
Very good. Tell us a little bit about the law offices of Crystal Moroney.
Okay. So as Mike advised, I've been an attorney in both New York and New Jersey for the last 12 years. For 8 of those 12, I have owned and operated my own firm, Law Offices of Crystal Moroney. And I predominantly do debt collection and creditors' rights law. And I do consumer and commercial recoveries, mostly consumer. I'd say that's about 80% of my practice, 90% of my practice. Prior to opening and operating this firm, I was a maritime lawyer, and I did cargo recoveries in Manhattan. Arrested ships and did grapes and fruits was predominantly my target. So one kind of cargo recovery led to smaller balanced consumer recoveries And that's when I opened up my own practice, seeing a niche in a lower balance market, that there's just not a lot of law firms that do this, and there is a combination. You have an agency or you have litigation, but there's not a lot of negotiation in between. And so my firm kind of fills one of those gaps in our industry.
And so I think before you've described either the technique or the style of recovery as soft collection. Can you explain what that means?
Sure, yeah. We say firm but fair is kind of the motto in the office. So a collection agency tends to have a script, right? They're working for the creditor direct, and they want to get it paid, whether it be paid in full or just that's it goes to litigation. What happens if it doesn't really qualify for litigation, right? It's like $1,800. But they're ignoring the collection agency calls. What we do is we step in after the agency. So these debts are older. They've had an opportunity to resolve them, and we negotiate. So a lot of times they'll either have an attorney on board at that point, or we're still dealing with the consumer directly, but we offer payment plans. We might offer some settlements. We also go through what our client can do, right? So they can sue. We don't threaten suit, but we also don't take that off the table, because there are some clients that I have that do look for suit, and then I will find them either a local attorney or we'll sue in the tri-state area ourselves. Nowadays, when Mike says soft collection, it's a highly targeted industry, and it gets a lot of negative publicity. But it's unfortunately, there are bad players in every industry, but the ones like myself that are licensed and operating, we have a great deal of respect for the people that we're working with, and most of our calls are very soft. We are looking to work with the consumer. We want to get it paid. We explain that it'll help them, it'll get it off their credit. It will prevent litigation. They can move on with their lives. Unfortunately, some pay, some don't, and it is a tough industry. Some calls are very tough. We take a lot of abuse. My staff takes a lot of abuse, but there is that middle ground of trying to get it resolved. We look at it as not only a necessary service, but also a soft collect. We protect the client's reputation as well as our own. We try to get the consumer on board to get it resolved.
And your clients then are the debt collectors?
That is correct. So some of my clients are agencies themselves. Others are creditors directly. So they'll have a relationship where they might send it. When we say, again, soft collections, nobody wants to go straight to a lawyer, right? Call up my consumer or my customer. They'll go through a primary collection agency first. So they're just getting kind of standard calls. They're not getting a whole lot of information, but hey, here's another copy of the invoice. Once that's passed, say 6 to 9 months, then it comes to my office. And that's when we explain a little bit more about, hey, it is at a serious stage. It does have to be paid. We could do a payment plan, but we got to take this serious. If you don't have a paid in full tomorrow, let's work out, an arrangement for the next year.
So, Ron, how did you meet Crystal?
Well, Crystal tells me, I don't have a specific recollection, that we met at a conference of the National Creditors Bar Association. It used to be called the National Association of Retail Collection Attorneys. So you're going to have to fill in the rest of my...
Let's not go too far back. Why did Crystal turn to you? I think it would have been somewhere around June 2017.
Well, I had known Crystal before and had handled a few minor matters on her behalf. And in Florida, I think, and maybe one, I forget where else. So Crystal had called me when she received the notice of the civil investigative demand, and I think was startled, and I think startled's the best word, right?
So what civil investigative demand then is, the easiest way to describe that as essentially a subpoena. It's an administrative subpoena, but it's not a subpoena that the CFPB, so the Consumer Financial Protection Bureau, it's not one that the CFPB can enforce on its own, can it?
That's correct, and I guess I caught myself in government speak or something. Civil investigative demand. It's, I think, akin to, as you say, to administrative subpoena. I think a lot of agencies, from what I understand, send them out, like the Securities and Exchange Commission. What was unusual about this is there was no stated purpose or reason for the investigation. It was the generic, we're investigating to see if you violated the law, which, and I sort of rubs people who are experienced in the law a little bit wrong. I mean, you've got the right to have some understanding of what people are, why are you being targeted? What has singled you out amongst the hundreds or thousands of debt collection law firms that are in the country, or the hundreds and thousands of collection agencies. So that was one thing that stuck out in the beginning when we received it.
And other than, so that was the notice of purpose portion. So
Right.
they're not giving Crystal really notice of why they're doing this. Did they give you any indication that there was a complaint from someone, or that there was a particular practice that they were investigating, anything like that?
No, so that's an interesting question, because that was, of course, my first question. Why? I had not only advised clients how to handle the CFPB or how to be compliant with their rules and regulations, but I also had and still do, an A- business rating, very few state complaints, very few lawsuits. I mean, like I said, this is a tough industry to be in. It has a very negative view publicly, and so people get sued all the time in our industry, and I had very few of all of those complaints. Better Business Bureau, Attorney General investigations, and anything that I did get, I'd provide copies of the notices or the invoice, conversations, explain what happened, and most were closed out within under 10 days. And that was the history I had had for, at that point, 5.5 years. So to get this, and it comes in book style, phone book style, I was shocked. And then the first question was, why? It can't be from an excessive amount of complaints. I had also sat on enough industry conferences where CFPB speakers were present, and they would say, if you're getting 1,500 complaints a year to our office or on our portal, we're certainly going to start to take a look at your business. And I knew I had in 5.5 years 4 CFPB complaints that were all closed out within a week, that I had submitted my summary of what happened and a copy of either the invoice, the check, whatever the debt might have been in question. And they were closed out, and I never heard from them again.
So, Ron, let me ask you this. What sort of information is the CID looking for? Are they looking for production of documents? Are they looking for answers to questions? What is the substance of
Yes,
this type
both
of-
plus more.
All of the above.
All of the above. And one of the features of the civil investigative demands from the CFPB is that they want you to prepare reports. I recollect our report was about any complaints you ever had, maybe. But it was more than that. And when Crystal refers to a book, the Consumer Financial Protection Bureau has promulgated document production standards, which work for Facebook and Google, but really don't work for Crystal Moroney, because they are extensive ESI, electronically stored information, that a small operator, a small firm like Crystal's, just simply can't comply without spending tens of thousands of dollars on IT programming to produce the records and the documents in the fashion that the CFPB wanted. That was one of our challenges, but really the other challenge was, why am I being investigated? And this I do remember. She came. This is, I think, pretty standard with administrative investigations. The investigator, the bureaucrat, not to use a pejorative term, asks that the target meet and confer to talk about the request. And we did that in person. Crystal wanted to come down. I remember it was the day after July 4th, and she said to the 2 enforcement attorneys, "Why am I being investigated? What complaints do you have? Why am I being targeted?" And they said, "We don't have to tell you." Now, that was very significant for a couple of reasons. I want to just take a minute to explain. That was during the final months of the term of Director Richard Caudray. He was appointed by President Obama to be the CFPB single director czar. And the way the administrative process works is, if you want to object or move to modify or quash the CID, the director decides whether to do so. And Director Caudray had written several published decisions that determined that the law doesn't require a notice other than to say, we think you violated the law. Since that time, the new director took over, announced a change of policy that says, we are now going to tell you the specific information that we are investigating, the specific reasons of our investigation. And that actually became an issue in the case that I handled for Crystal in the Southern District of New York.
Let me pause you right there. So let's deal with this single director thing. So let's talk about the structure of the CFPB. CFPB is an independent agency. I'll put finger quotes around independent agency. Independent agencies typically have 5 commissioners, typically don't allow more than 3 commissioners to be of the same party. Typically, the President of the United States appoints the chair of the commission with the consent of the Senate. That's not the case with the CFPB. The idea of an independent structure is to leave the agency within the confines of the executive branch so that the president can have some, but not total control over the independent agency. At the CFPB, instead of a commission, they have one director. Cordray at first, currently it's Kraninger. The director can only be removed for cause, so only for bad behavior, which means the president can't influence policy. The president can't supervise the director's activities. The director has a 5-year term. 5 years is longer than the term of any individual president. Also, the director can basically stay for lifetime if the Senate never confirms a replacement. So, which is a clumsy way of explaining, you have a 5-year term as director. If the next president comes in and tries to nominate someone to take your place, if the Senate doesn't consent to that replacement, well, that director can just keep directing, which is absolutely outrageous. Then, of course, we have to look at the funding of the CFPB. Most organizations get their funding through Congress. That's Article 1, Section 9. Appropriations Clause says all appropriations shall be made by Congress through law. Law gets us to Article 1, Section 1, the vesting clause, all law, Congress shall make all law. But that doesn't happen with the CFPB. Instead, they send a letter. It's 1 page long. It's really not a letter. It's just a request. And it says, please, Fed, send us a check for at least 12% of your annual receipts. That's literally what they do. And actually, at this time, that's the statutory cap that then allows, based upon an index adjustment, I believe right now it's at about 14% of the Fed's receipts. Just goes to the CFPB, just because they want it. And oh, by the way, the statute, Dodd-Frank, Title 10, is where we find the CFPB. It was passed in 2010. The statute itself says that the House and Senate Appropriations Committees are prohibited from reviewing the budget of the CFPB. The Fed chair who has to write the check to the CFPB isn't allowed to question the money that he's being asked to surrender. It just doesn't. It doesn't make any sense, except if you understand what Congress was trying to do. They did it well. They wanted to keep the CFPB totally insulated from all political influence, which means totally insulated from all political accountability. Power flows through the people. And the only way to keep tabs on a government agency is through the constitutional process. And that's not what the CFPB is. So just to sum up then, we have a delegation problem because the CFPB is delegating its exclusive responsibility to appropriate funds. And we also have a separation of powers problem because the president isn't allowed to control the executive branch. And so we talked a bit about that first CID, talked a little bit about the meet and confer. Now that we understand what you're up against, because you basically have a director who is accountable to no one but herself, what is the next part of the process? How did you go about, Crystal, fighting or complying with the requests made of you?
Okay, so what we started to do was to take it apart, right? So one by one, as I would when I litigated, started looking at what I could turn over. I wasn't hiding anything, so I said, let's see what we can comply with. Maybe that will help understand that I'm not doing anything wrong. They can maybe narrow down what they are interested in seeing, and we could have some conversations and keep this cost effective at this point.
What they were looking for, though, is basically her list of clients.
Right,
And
client contracts.
all records relating to communications with with the accounts and with their client and with their clients. That's basically what it was. They wanted your whole filing system.
Right. Short of emptying the office, and they wanted it in such a way that even the stuff I could give them, right? Some of the collection scripts that are not client confidential, some policies in the office, how we do hiring, how we do background checks. That stuff wound up being, even that was conversation after conversation, because when I asked my IT team and I gave them the packet of how it had to be formatted, they gave me a bill. They said, okay, we could do this. It'll take, X amount of weeks, and it'll be about $70,000. And I nearly fell over. I thought, there's no way. So we had to talk with them then. Hey, listen, we can give you this particular information because it's not against the client confidentiality. However, I cannot give it to you in a format that will cost my business $70,000. And there was back and forth, and it was, well, here are the options. One of them was slightly less money. And they said, but we really want it like this. This is how our data team could process it, because they really put it through machines at that point. And then some other stuff, as Ron might go into, was intertwined. So I'm a small business, right? And if I'm working on a file, I might note it with some attorney notes. I'm not by law required to not put those notes in my data system, but then I found out from my IT team to extract those would be, again, just hundreds of thousands of dollars. And they said, well, don't worry about those notes. We'll just bypass them. We'll read them and we won't tell anybody. It was basically really their explanation. And I said, I'm young. I need to make a living and support. I have twin boys. For many years to come on my licenses, and I would never do that to my clients or my reputation.
What do they
this
tell you
seriously.
about the application of attorney-client privilege material when it comes to the government?
It does not exist.
Oh.
Well, it was, we can decide what
We'll
it
decide,
is.
right.
We'll
Let us see
decide.
it.
And in fact,
Yeah.
there is a specific regulation, I wish I would have brought it, that the CFPB has a right to decide what's privileged, and if they decide it's privileged, then it's privileged. But you have to give the information to them, and they're the arbiter.
And so now I have a malpractice claim, and they've already seen it, and then they could say, oh yeah, I shouldn't have seen that because you're right, it is privileged. I mean,
I
as an
don't know
attorney,
if-
it's horrifying.
I don't know if they've challenged, the CFPB has gone so far as to go to court and say, we have the right to do this, but it is in their regulations because of the nature of the delegation of authority from Congress to a single director to remedy the financial crisis, so to speak.
So, Ron, let me ask you this. So there sounds to me like there is some give and take. There is some negotiation here. So the CFPB was willing to move on some things and not move on others. But I seem to recall that there were problems with tight timelines. What can you give us maybe one example?
Well, I think the negotiation is more it's their way or the highway, but
Okay.
but be as it may, yes. And this is my experience in other investigations too. They impose draconian time limits. Did we have a one-day time requirement in
Yes,
one of our
several
cases?
times.
Yeah. Please respond within 1 day if you're going to do this. And my reflection is, having practiced in federal and state court, for 40 years now, no judge would put up with that. Yes, there are tight timelines. The negotiation, I think, was more about the format that we would give the information. Where the contentious part of it arose was because Crystal had rightfully refused to produce information relating to the representation of her clients and had sought out an opinion from an ethics counsel, very experienced attorney, who confirmed that and who said, look, you just can't turn this over without client consent or an order of court.
So, Crystal, then, if I'm understanding this correctly, let's make sure we got the timeline too. So, the CID was issued in June 2017.
Correct.
And the time, are we up to October 2018?
Oh, no. All of this happened in the first month or two. the
First
negotiations.
3 months.
First
Yeah,
3
it
months,
was-
right.
Right, October.
Yeah,
right, by
October 17,
we were.
October 17, and then it's silence.
Okay, so so by October 2017, you hired Ron and John to help you out with the CFPB. They're coming back and saying, privilege, smivillage, we want it anyway, like, let me get an independent. So you have to hire a third
That is
attorney.
correct.
including, and you've already hired IT experts too to help you with your compliance requirement. What about your time? How much time did you spend, up to this point? You've got.
So those first few months when I was trying to comply and have discussions with them and answer on their timeline, it was like 6-7 hours a day I was dedicating to keep, in my mind it was, this is survival, right? If I don't do this, then I'm going to have fines and problems, so let me just focus and try to do this. But it was, week after week, and you're getting nowhere, and you're spending 6 to 7 hours a day, and then also weekend time. I'd go in on the weekends and try to, see what else, talk to IT individuals at night, on Saturdays. What if we do it this way? Can the system be paired out a different way? And it just wasn't possible. And at one point in October, I said, look, this is privileged information. This is it. I've given you everything I can. And we're now at an impasse. And I can't, by ethical standards and my bar license, give you any more. What I gave you is what you have to review. And if at that point they also had policies and procedures, I said, if there is something that I'm doing wrong, you should tell me, and I will change it. I want to be compliant. I want to operate in this industry for a long time. And they said, okay, well, I think that was one of the times that they said, well, within probably about 30 days, you're going to be sued. Or we're already drafting the complaint for federal court. And John.
That is the complaint to make you turn, to force you
Yes.
to force you to turn over the privileged materials.
Right, and I had a conference with John, and John is another attorney that works at Ron, and they said, well, this is reality now. You spent tens of thousands of dollars in these few months trying to comply, and now you're going to wind up having this federal suit against the firm, which of course nobody wants that kind of publicity. And how I described it to them, I said, well, at this point, I'm maxed out. I'm spending so much time and so much money, and I'm getting nowhere on valid claims of privilege that anybody should really respect. And so at least, I think I joked with them, I said, I feel like I'm getting beat up in the back of the playground at school, and nobody knows about it, and I'm bloodied and battered. Bring it into court. Let's put on at least gloves. Let a referee monitor this fight. Let a judge say, hey, this can be done or it can't be done. But at this point, if I'm going to still be spending time and money, we need someone, a third-party, impartial judge to view this, because this isn't right.
And think about that for a moment, too. Nobody likes to be sued. Nobody wants to go to court. Litigation is expensive. It's risky. Anything can happen. No matter how good your facts are, how strongly you think the law leans in your direction, there's a lot of risk there. But when a government agency pushes you to the point where you're like, oh, thank God we're going to court. Woo!
And that
This
really
is going to be
was-
amazing. That's how she feels, because you know what? They're not following any federal rules of evidence. They get to make up their own rules and regulations regarding how they operate. And, well, that's not okay. But I think the larger issue here is at least we're finally going to get an opportunity to press this in court, or will we? And so let's turn the page to really it's funny to note. So the CFPB didn't file its petition to enforce its CID against Crystal until January 2019. How much time was that between the time they said?
I thought it was like almost a year and a half.
I think, 14
Yeah.
months.
Yes.
So about a year and a half later, they're like, okay, finally we'll do it. But they didn't even tell you. They didn't serve you with anything until when?
Well, they filed it, and I found out from kind of news reports that this had been filed, and I thought,
Didn't a reporter call or
a
something?
reporter called me for a statement.
Right.
They didn't bother to serve it until the court ordered them to serve it,
which was
in September.
Right.
In September 2019. All right, but we're going to get there at least.
Well, yeah.
November 8th is the hearing date. The CFPB ends up, so it's a petition. Crystal files a response. Ron did a great job. Ron, what were the issues that were going to be tried?
Well, fortunately for our point of view, but in the interim time frame, there were some significant legal developments that challenged the CFPB's structure. There was a case out of the Southern District of New York, the same district where Crystal was sued to enforce a subpoena, called RD Legal Funding. In that case, the former chief judge of the district court, Preska, is that her name?
Prescott, yeah, Lorraine Prescott.
Ruled that the Article 10 of the Dodd-Frank Act, which imposes the four-cause removal requirement on a single director, violates Article 2 of the Constitution. That is the president's obligation and right and duty and sole obligation to faithfully enforce a law, declared the statute unconstitutional and dismissed the lawsuit. That is now up in the Second Circuit. Additionally, there's a case called Celia Law versus Consumer Financial Protection Bureau that is being argued on the 3rd. And in that case, the court accepted cert on the question of whether the for-cause removal is constitutionally infirm. And the second question is, if we find it is, what is the remedy? Now, the CFPB, because it's now under a more conservative administration, agreed that it's constitutionally infirm, that the structure doesn't comply with Article 2, but argued in the Supreme Court that the remedy is simply to allow the president to remove the director for any reason, and that cures the defect, severing that unconstitutional provision in the statute from the remainder of the enforcement and regulatory structure of the CFPB. So what I argued is, the first argument was, this is the same court that decided RD legal funding. The structure is unconstitutional. The remedy is dismissal of the case because the entity, the agency, is an unconstitutionally created organization. The second argument we made was that the notification of purpose was improper. It didn't comply with the law. Since we had our meeting and were told, we're not going to tell you what the purpose is, there were two circuit court rulings, I think one out of the Fifth Circuit, one out of the DC Circuit, dismissing civil investigative demands that had a generic notification of purpose. So that was the second. Oh, by the way, also in the interim, as of April, the director agreed to change her policy, and now they would give a specific notice of purpose. The third argument was, this is privileged and we can't produce it. So those were the arguments that I had prepared to argue before the federal judge on our motion to dismiss.
And so you were ready to try this case. And,
Absolutely.
And so to this point, you've spent how much?
At that point, it was about $75,000.
Okay. And you talked about how much time you spent, days, nights, weekends.
Sure.
But what about, what were, I should phrase it this way, what weren't you doing while you were trying to comply with the CFPB?
So it's tough because business development was one of my number one. Being the president of my own firm, I was the rainmaker, and you're not exactly, calling up clients and trying to get new business or going to conferences and getting your business out there when you're spending 90% of your week fighting a government agency. And so almost all of the business development at that point was non-existent to my firm. I also had employees not doing their regular tasks on a daily basis and helping me get these documents, work on the data, work on the IT questions, get it into a format on the stuff that we could produce. And then we had the litigation going on, so I was also spending just a lot of funds in legal, so I couldn't invest in equipment. I got to a point where, and I'm not embarrassed to say, you're afraid to make future business moves. So prior to the CID, I would say, okay, I'm going to sign a 5-year lease. I got the better deal. It started to become, you know what, I'll do month to month, even though it was more expensive because, God forbid, the legal fees go up again, or maybe I should decrease staff, and I did that as well. I started working too lean. I mean, it's one thing to work lean. I was working extremely lean, still am to this day.
Let's focus on that for just
Yeah.
a quick second. So you said you reduced staff. By how much? How many people?
Almost half.
Almost half.
Yeah.
How many people is that?
9
people?
Yeah, 9 or 10 people.
This is the collateral damage, too, that the administrative state doesn't appreciate. So think about everything that Crystal's been through to this point. She's about to have her day in court. She's not to put words in your mouth, but it strikes me that you said on a a couple of occasions here today that you're doing your best to comply. You want to do a good job, and part of doing a good job is complying with these government rules. But at the same time, you're stuck in this circumstance where you had to pay a ton for it. You've missed opportunities to grow your business, missed other business opportunities. But there's also this other human tragedy of these people who then we're out of a job. And they're not here. We don't represent them. That's not part of any claim that we're making. But it's just something to keep in the back of your mind that this is another casualty of a rogue government agency.
Sure.
And so the hearing is coming up November 8th. The CFPB has gotten a couple of
2
continuances,
extensions.
right?
Yes.
So, and what were those continuances about, Ron?
Well, the first one, I don't think the first one,
Was no reason.
no reason, but we simply said to the judge, if they're going to do it, give us more time for our response. And the judge granted it without prejudice to our right to file a reply. The way the rules work in that court and the way that, because it was, I didn't have the right to file a reply. As a matter of course, you had to ask for it. Which is the way it is in some federal courts, not necessarily in the District of Maryland, but for example, just as an aside, federal courts like, for example, in Pennsylvania and some in Florida do not countenance reply briefs unless you get permission.
Okay. But CFPB does get a couple of extensions. I think one of the things that they wanted to look at was the Celia Law case in particular.
Sure.
They were
Correct.
concerned as to whether or not the Supreme Court would grant cert. And even represented to the court that whether it grants cert does impact what we want to do, how we are going to respond to this case going forward. But November 4th comes along.
Well, I think,
Oh, sorry,
no,
am I missing-
and an important point is that second extension, they did give a reason, and it was three nights prior to the hearing, and they asked for another extension, and I thought for sure, don't give it to them. Like, this has gone on long enough, we have the hearing coming up. And they granted it, and the reason was, and they put this in their request to the judge, was that they needed upper management to review this entire case. And I thought, like, this has been my life for the last 3.5 years, and now some attorneys give us a couple more days because upper management doesn't really know what's going on.
But they only gave them a day.
They gave them 1 day, right. They wanted
to
3.
file it. No, they wanted to file their written memorandum the day before the hearing, which
Right.
would obviously have put us in a substantial disadvantage because you got to study the cases, you got to consider their arguments, and try to come up with a rebuttal if need be.
Yeah, but what they ended up deciding to do with their time was prepare a filing called a suggestion of mootness. And here's another opportunity for some finger quotes because it's not a suggestion. They actually say in there, this court must dismiss this case because we are withdrawing the CID. And so since we're withdrawing the CID, you've got to dismiss it. There is nothing here before the court. That's their representation anyway. There is no controversy between these parties before this court.
I know it wasn't intentionally, but we do want to fill in the history. The day their response is due, I get an email that says, from the enforcement attorney, we are going to be withdrawing the CID. I sent it to Crystal, and I wouldn't be remiss if I didn't acknowledge my counsel, John Bedard, who worked on the case with me. John's Georgia lawyer. He's very conversant in these issues, more technologically astute than I am, so he helped on some of the technological issues, and he's just a very fine lawyer. In fact, he got the Integrity Award from the Receivable Management Association at our conference a couple weeks ago, which I think is a very, very good thing to have. Anyway, so I sent the email to Crystal and John. I said, look, it looks like they're going to back off. They're not going to challenge our assertion of privilege. They're going to address whatever we gave them and decide what they're going to do. That was my impression. They're going to decide what they're going to do with what we gave them. They're not going to try to enforce the CID further.
But
Go ahead. Okay, but that's fine. So they filed that suggestion of mootness and, motion to dismiss. And of course, we're not going to. What are we going to object? Hey, we accomplished what we were going to do.
high fives all around.
High fives all around.
Sure, such relief.
We'll address whatever they want to bring, whatever type of enforcement action, whatever type of settlement. I remember Crystal saying before the first meet and confer, hey, look, if I did something wrong, tell me what it is, let me pay a fine, and let me get it over with,
We'll
okay?
fix the policy. I mean,
Right,
there's
you know.
so many really detailed rules in this industry. You know, your letter could have a comma that's off, and you can get fined for that. And I said, if there's something like that, a consumer attorney by now would have, you know, nailed me on it, because this industry is really run heavily by them. And so I thought, well, you know, my letters are good and everything's good, but if they find something, tell me, I'll fix it, and then whatever fine it is, we'll pay it now and move on.
I mean, if you went 10 miles over the limit and you were, or 9 miles and you were caught on 95, oh, okay, you know, let's see if I can reduce it and pay a small fine. So they dismissed it, and we sent the notice out to John and Crystal. 4 hours later, I get an email from the CFPB. We are now going to be issuing a new CID that includes a more specific notification of purpose. Will you accept service?
So, the same CFPB attorney
The same day.
That files the suggestion of mootness is the same CFPB attorney who emails you to be like,
Well, they waited until the
Just
judge
kidding.
signed it, right?
yeah, well, they
Right,
waited.
they waited till the judge signed it.
signed it, sends out the email, and then a week after that issues. So it'd be November 14th. A week after that issues the second CID, which, like you said, it modified the notice of purpose. Gee, thanks. Don't do me any more favors. And but
The substance
otherwise,
is the same. They're
the
looking
substance
for
is
the
the same.
same exact information that we already gave them
And yeah, it's
or objected to.
So
Right.
you could call it a second CID, you could call it a reissued CID. No matter what, you're back under the microscope again.
I am back at square one.
Yeah,
It's
back-
worse because here I got the night, you know, a couple days before the court hearing, and I thought, okay, you know, they see the privilege, they have what they are going to review, and then we'll have some conversation after. The judge signs the order. We're kind of
Actually, she's a character in a Kafka novel because that's what it is.
And you tried to reopen the case.
Okay, so, you know, I did my research. I said, this mootness is contrived. I found a case that Judge Preska had decided, the one who decided the already legal funding, that had refused to dismiss a case that involved a constitutional issue on I think it was billboards or something. And the local agency, the local government, whether it's the city council or whatever, had gone ahead and changed their regulations so that the offensive, the violation of the First Amendment was no longer viable. But Judge Preska said, no, you can't moot this because it's still an open issue. So I asked the trial judge originally, I cited this case, I said, this was a fabricated issue of mootness. We want our day in court. So we went up there a couple weeks later, and the judge basically, his attitude was, there's nothing before me, it was dismissed. You have a problem with their harassment, go ahead and file something else, but don't come back to me.
And so we'll go to now back to our citations, and we'll talk about Fifth Amendment due process. You have a due process right to be heard. You have a due process right to a fair trial. And by manufacturing mootness, and you know, I don't make light of that suggestion either. Just look at the facts and the series of facts for yourself. What could the CFPB possibly be trying to do here? They go ahead and they file the petition for enforcement in the first place with the first CID. So in other words, they must have thought it was important enough to go after Crystal to force disclosure of attorney-client privilege material. Let the court sort that out. That issue is still a live issue. They bring back a second CID. Let's just give them the benefit of the doubt and just suppose that they thought that the defective notice of purpose, an argument Crystal had been making for 2.5 years prior, suddenly like, oh, wow, she was right all along. This is such a big deal. I don't need to just modify it and tell the court, look, we're going to change that. We realize we're wrong. Let's just proceed to trial on these other issues. No. This is really serious. We need to withdraw the whole CID. Well, okay. In reissuing the next, why then not immediately proceed to enforcement? If this was important in June 2017 and you decided to enforce it in January 2019, what has changed between then and November 2019, January 2020? And so, you know, we sit here with this violation of due process that, and Crystal, correct me if I'm wrong, but I don't think we'd be sitting here today, and I don't think we'd have a lawsuit in the Southern District of New York had they just gone through with the trial.
Yeah, absolutely.
The
Judge would have.
The judge would have decided whether they were going to enforce it, and if so, she would be under an order to disclose the information, and then in consultation with the ethics counsel, would disclose it, because I think Rule 1.6 allows you to disclose if ordered by a court. I mean, she doesn't want to do it. The clients don't want her to do it. But if the judge ordered it, then you have a protection as an attorney from violating Rule 1.6, because it's by court order. Now, we have serious doubts whether the court would have ordered that.
Right.
Right. And so what we did was, at NCLA, we took a look at Crystal's case. She has a problem. She spent a ridiculous amount of money on the first CID. And as I was saying before, that at some point does become a cost of doing business, a bit of a sunk cost back then. But going forward, if she has to defend a second one, duplicate, that's right, duplicate CIDs, I mean, how can anyone afford to do that? Her law firm is already at the brink of insolvency. Crystal, can you have cut your own salary, haven't you?
I've cut it twice.
Twice. Can you cut your salary any further?
No.
And stay in business?
No, absolutely not.
And you mentioned you have a skeleton staff, and you're probably running too small as it is. Can you
Yes.
cut anyone else out of
No,
that?
absolutely not.
The constitutional harms, such as the due process harms that we're alleging, are per se irreparable harm. But there's also a danger. We'll go back to the citations that I brought up in the first little segment of the First Amendment gives you a right to petition the government for redress of grievances. Crystal's law firm isn't going to be around if this is allowed to continue. So we had to act, and we had to act quickly. We filed a verified complaint in the Southern District of New York, and what we're looking for is really quite simple. Declaratory judgment from the court that the CFPB is unconstitutionally structured, that you can't have a single director removable only for cause, that it's unconstitutionally funded, it can't receive funding from appropriations that don't come through Congress making law, that it has abused process through the course of manufacturing mootness, and it took on the unique, what I hope is a unique strategy. Maybe they do this all the time, but they haven't just picked on you here either, have they?
No. So shortly after we found out that they were issuing a second CID, and I was just dumbfounded, I mean, beside myself, because the administrative process with the CFPB in the beginning, before they even decide to enforce the CID, is you either waive defenses or you have to go through the structure, meaning the meet and confer, a motion to set aside or squash. And so that alone was about $7,000. And I knew I've already done that, and this is an identical CID, and here I am doing this all over again, and there's nowhere to turn. I can't do that. I can't say, well, I'm just not going to answer at all, because then I waive those, and that's the way the statute's written. So I had to, again, start spending money, and then I find out while I'm going through this completely, I mean, it was like deja vu. Identical process, same material, same arguments. We're having to now make them again and go through the meet and confer for a few hours. I get a couple emails that I just thought, oh my goodness, this is terrible. I now had clients that were receiving CIDs themselves, asking for the information that they share with my office, the very privileged information that they're not entitled to, that we were in court days ago to have a judge decide. They are now going direct to clients, and on their CID, it is law officers Crystal Moroney all over it. And so, of course, for any company, right, you start going after your clients. Clients go, oh, I really like you, and I think you do a great job and great service, but we don't want to get caught up in this, especially with the CFPB's reputation that it's really costly and just almost a no-win. And so when clients started reaching out saying, hey, what's going on? Do you know about this? I just thought, well, this is it. If they can't go to court on it, they're going to try to basically destroy my practice by making all the clients leave.
It really is remarkable. Hopefully we have an opportunity to discover, to learn a little bit more about whether this is a regular practice or not. But we want to alert the court to this problem. And by manufacturing mootness, by avoiding judicial scrutiny in this manner. I mean, keep in mind, you CFPB are so thoroughly cut off from any accountability to the political branches that should be good enough for you, but it's not. You also want to be cut off from accountability to the last hope that we've got, and that is a judiciary that is going to rule whether or not you are acting constitutionally. Because, Ron, One of the arguments the CFPB is making is, Crystal, it's a cost of doing business. I'm sure she doesn't like it. But in the end, she doesn't have to do anything. She doesn't have to do anything. She doesn't have to worry about anything until we go to enforce a CID, because it's not self-enforcing.
Well, she's already been done to, so to speak. And Mike, I have to give you loads of credit for your excellent briefing on these issues. And I'm both of us are.
It's a team effort.
No,
stop,
but look, Crystal and I are, and particularly Crystal, because she's the client, are extremely gratified that your organization has taken this case. I mean, it was somewhat of a, like a reaching out for some way to defer the cost.
It gave me hope again.
It gave her hope again, and I was so fortunate to get a reference to Peggy and to your associate, your alliance, and a lot of what you're doing certainly resonates with me personally. But talking about Mike's, briefing, it's like they believe they are a law unto themselves. What they're saying is, there's no need for judicial review at this point because she hasn't been harmed.
And then they say, and if you want to go to court, we'll decide. If we're going to enforce it, then we're going to go to court. But for no other reason, unless we bring you to court, can you go to court? You can't go to court. You don't have the right to do that. We're doing this all, I say, behind the scenes, because it's through their administrative office.
The chutzpah of it all. I mean, just to take the first CID, go to court and say, please exercise jurisdiction, Your Honor. Please make her do the things that she doesn't want to do. And then when she goes to court and says, hold on. I still have a bunch of issues with this same organization, the same people, what they're doing to me. They manufactured mootness. I need you to exercise jurisdiction now to decide these issues. Instead, the CFPB is now saying, no, the court will hear this case when we're good and ready. And that's not how the system is supposed to operate.
Their argument seems to be like Deja Vu all over again, or Groundhog's Day, the movie. I mean, you can continue to do this, continue to have the same continue to face the same scrutiny, and have no available judicial relief. That sort of goes against what we've learned and understood to be the tripartite system of government that we allegedly still have.
Right.
That is, that there is when you want you're entitled to a remedy from the executive when the executive is doing something unlawful.
That's right. And so what we're doing a week from today is we have a motion for preliminary injunction in the Southern District of New York. What we're going to try to do is enjoin the CFPB, should put it this way. We want the court to suspend the CFPB's investigations plural, of Crystal. So don't do anything more with respect to this second CID. Don't go after her clients. Don't go after any new clients while this case is pending, because there are ongoing, systematic, irreparable harms here to her rights to due process, and as I mentioned before, potentially her right to petition the government for redress of grievances. If her business isn't here in a few months, then there's no case. The CFPB, as Ron said, the CFPB has argued there's nothing to see here. You can decide this case when we're good and ready. They've also made other jurisdictional arguments that don't really hold water. Hopefully the court will see it our way. The CFPB is trying to distract from some of the issues that we've raised in saying that we are attacking the CID itself, which is not the case. That is completely wrong. If the court grants the preliminary injunction for which we have asked, all that we're enjoining is the investigation. If the CFPB wants to enforce the second CID, they can do so. That's not going to be subject, at least not to the preliminary injunction that we've requested. And the court might want to do that on their own, but that's not what we've requested. We just want our day in court. Crystal thought she was going to get that in November, and we hope to get that this time. So, anyway, I don't know whether you'd like to add something or whether we should get some questions.
Well, I think questions would be good.
Let's get some questions.
Somebody's sitting here listening.
One of the things we talked about earlier with respect to the CFPB's funding is the non-delegation issue. We had raised the concern that Article 1, Section 9 requires Congress to appropriate funds to agency operations and to do so through law. And so Article 1, Section 1 with a vesting clause, since all law has to be made through Congress, Congress can't then say, you know what, CFPB, you can go ahead and self-fund and operate through letter from the Fed. This is a violation of the non-delegation doctrine because it's a willful divestment of Congress's exclusive authority. And as I think I also mentioned before too, the separation of powers aspect is you're trying to hermetically seal off an independent agency from all presidential control, though the president is in charge of the executive department. Yeah, I think we get some questions back there. Do you have the microphone? You can.
So I was under the impression that, if you're a wrongdoer out there and you stop doing the wrong thing and ask the court to dismiss it so that you can then restart that as soon as the case is dismissed, that isn't really moot, that you have to intend to stop your activities at least indefinitely in the future at the time for that to be mootness. So why isn't this fraud upon the court to say that they were not intending to do this anymore and then they did it?
That was my exact reaction. I said, this is, sliming on the desk like a movie scene. This is a fraud on the court. That is exactly.
That's a great argument for Mike to make next week because Judge Roman, who is the judge who dismissed the case at the request of the CFPB, wasn't motivated to get back into it. Is that fair to say?
Absolutely.
He's saying, it's not my problem now. There's nothing before me. If you've got a problem with the new CID, you think you're being harassed, do what you have to do.
And those were actually the judge's words. We had never stated harassment or harassed during that in the transcript. And he actually said, he asked the government's attorney, is this substantially the same CID? Or is that what counsel's arguing? And they said, yes, Your Honor, this is substantially the same CID. And he even seemed a bit surprised. And then he looked towards me and said, nothing's before me. I'm sorry. But if you think you're being harassed, you should, tell somebody and go about it another way.
It was a very short hearing.
Tell somebody.
It was a very short hearing. I mean,
here, Your Honor.
the idea was,
Yeah, we're right here.
you deal with judicial restraint and the judge's inclination not to decide cases they don't have to, and that was well apparent there.
Sure.
And my hope is that the court is going to be at least curious. The CFPB certainly lacked candor with the court. I don't think that that's in dispute. The attorney who was working on the first CID is not, well, she did issue the second, but she does not represent the CFPB in our case in the Southern District of New York right now. I would think the judge would have a few pointed questions about what were you thinking and why would you do something like this?
Right here. This is something I'd like you guys to give some thought to. When the court cases are all completely over, put some real thought into doing your after-action report or case study, and when you do it, try to be as specific as you can regarding the amount of money spent, and the number of man-hours billed out, the number of employees you lost, the cost to the business. And the reason why I say this is, listen, everybody here's a policy wonk of one kind or another. We're interested in these things for their own sake. Ultimately, that's not how this kind of a government-funded abusive behavior gets solved. It has to enter the popular narrative. And policy issues aren't exciting to the general public. They could really just care less. On the other hand, saying, I'm a private business owner that got railroaded, this cost me $3 million over 5 years, that's a very powerful narrative that can work politically to get changes made to the system itself. So
I agree.
again, not something to work on today, but to the degree you can, try to put something out there that's accessible beyond legal journals, beyond legal review documents, because the people who would fund those political movements aren't going to read that stuff.
And that's a really good point too, and I think it'd be interesting to do it from the perspective of percentage of income in the first place. Just revenue versus cost. I think that would be very interesting. It's a good idea. The microphone's coming to you.
I gather that perhaps the CFPB has some adult supervision now. You mentioned that prior to the November hearing, they asked for a delay in order to meet with supervisors. Is there any way of finding out whether the supervisors were told of the plan to dismiss and then refile, and whether they actually approved that, or if they just were signed off on actual dismissal of the case, thinking that that would be the end of it? Because I just can't imagine that if the supervisors knew what the plan was, if they would have endorsed it.
I, for one, am looking forward to depositions. I will just say that. I've got lots of questions, and those are a few good ones. When did you know that you were going to reissue the second CID? And it's entirely possible and this is something Crystal and I were talking about before, there have been moments in Crystal's saga where you think, you know what, this is probably just administrative incompetence. Like, you let something slip through the cracks, but then there are other times where it's quite clear that you're being targeted.
Right.
Like, there was a conscious choice. Let's go ahead and get her clients. And it will be interesting to find those things out, and whether it was just the left hand not knowing what the right hand was doing in some of those circumstances that you raise here, whether there was some larger strategy or two different agendas. It's entirely possible that there are multiple agendas at the CFPB.
Yeah, and targeting, I think I needed to add just a few seconds. The CFPB several years ago created a web-based complaint portal. So if you had a complaint against a regulated entity, you can simply file it. The entity gets an opportunity to respond to it. It's more or less like a Better Business or an Attorney General complaint, and most of them are resolved. So, Crystal had about 4 of those. Most companies have hundreds a year because anybody who's subject to a collection action, they consider themselves to be a target of abuse when they get their first letter or their first call. So those who are more motivated to whine and complain will go to the portal and late at night, send out a complaint even if it has no basis. Just wanted to explain that because when Crystal mentioned complaints, we're not talking about official administrative actions. We're simply talking about 4 consumers accessing a portal and saying, I couldn't pay the bill or something like that.
John?
Mike, I think it might be interesting. You filed a TRO in this case.
Preliminary injunction.
What happened?
Well, what we ended up getting was an order to show cause from the court. What we wanted to do was try to get a bit of an accelerated schedule without getting into the strategy, surrounding our tactical choices. Ultimately, we wanted to put before the court an opportunity to get us on an accelerated briefing schedule because of the cost that Crystal faces. And it isn't just monetary cost, it isn't just lost opportunity. There is also enough of an emotional taxing.
Absolutely.
It would be nice to get some resolution to this quickly.
The point was, how soon after you filed this suit did the court issue an order to show cause?
They issued the order to show cause the day after we
I was
filed
going
our
to say,
motion.
right, 2 days,
Yeah.
3 days.
Yeah, the day after.
Do you know, or do you have any way of knowing how common this is?
Well,
Ron, you might have more experience with this.
I don't think it is because there's not many cases where the target has fought back, and in the cases they have, they've been successful. Again, there were 2 appeal court cases that told the CFPB you can't use a generic notice of purpose saying we think you violated statute. You have to tell us what you did, what specific conduct. Crystal couldn't afford to do that back in July 2017. She couldn't afford to challenge it and then and then let the CFPB file a complaint and then go through this briefing process. It was simpler and easier to provide the information and simply say we can't give you the documents and information that are privileged. I don't think it's routine. They've only filed a handful of lawsuits in the past couple of years because they strong-arm people to settle.
right. And that's kind of common knowledge in the industry is they'll put a lot of pressure early on. It's like a legal extortion so that you pay out and then they just move on. And if it's really about the consumers, that doesn't help anybody. I mean, it really is $1 and then it's gone. Whereas in this case, this is 3.5 years and they've had my policies, procedures, and I've said, if there's something that I should change, you should tell me now. And I've gotten just nothing back but lawsuit, CIDs, clients now getting CIDs.
They really have overreached on this case. I don't think they anticipated that Crystal would continue to fight back. I don't think they fully appreciated the financial costs to her versus the income stream that she has. I just think that this is just a ham-handed attempt at a shakedown that has worked with most other law firms that are collecting.
Well, and
under
I'll be
their
honest,
purview.
but for this alliance, my fight might have been ended a few months ago. So that's why I say it really did give me hope, because now I do have a fight in the game, but without an alliance like this, I couldn't additionally spend more legal money with my administrative CID, the second one, still in the process, because I'm having to pay for that. And so this suit is actually nice to be on the plaintiff's side to see if we could get into to court to stop this.
There was a collection law firm that fought back in Ohio on an enforcement action, the Weltman firm. And curiously, they were a debt collection firm, sent out a lot of letters all over the country. One of their clients had been the Attorney General of Ohio when Mr. Caudray was Attorney General. Interestingly enough, he had used them to collect the state's bills. So they fought back, they won, it cost him $1.2 million.
He asked for fees,
And
I
they
think
didn't
the
get it.
court gave him
Just the cost,
$18,000.
right, just right.
Yeah.
But the point is that they are probably one of the largest collection law firms in the country. I mean, she could not afford that. This is a godsend to have this organization willing to take up the battle. When you listen to Mike, you say to yourself, you know, being a lawyer, I don't know how many of you are lawyers, but you say to yourself, you know, this case is really important. But you lose sight because whenever you're in a case, you think it's important. And sometimes it is, and sometimes at the end of the day, it turns out to be less. But there's an instinct that says, what's going on here has more impact than simply Crystal. It has the concept of, you know, as you say, the government is basically tooting their own horn. They play by their own rules, which they shouldn't be able to do.
Yeah.
Is it possible for Crystal to sue the CFPB for punitive damages for abuse of authority?
That's unlikely. You know, because government has sovereign immunity to the extent that there are sanctions available. That, you know, if the CFPB were to try, and I don't think we could reach back to November to get something like that, but to the extent that if the CFPB tries any sort of funny business in our case, we'll certainly be alert for it this time. Last time you couldn't see it coming. Right. You just took them at their word, like, oh, okay, fine, that's great, we win, high five. But, you know, here we'll be watching carefully. But no, punitive damages of any kind won't be available. But if they behave badly, I'm not afraid to file a motion for sanctions. It would be fun. Jessica?
Hi, I'd just like to thank Crystal and Ron for being here, and Crystal for being having the courage to fight back against the CFPB. And
Oh, I appreciate that. Exposure is really key. I mean, being an attorney, it's a unique client situation, right? Because you expect it to go a certain way. Right? There's rules, there's regulations, there's policy. And when you're the defendant in an action like this, and all those rules get thrown out the window, I mean, you become your own worst client, right? This isn't fair. Like, I felt like I had nothing else to say every day, but this is not fair. This is not how it works. Yeah. So now to have the alliance to come in and say, hey, we're going to sue them because this isn't fair and this isn't how it works, and you do have the due process right is really wonderful.
And so I just had a quick question if you have time. Apart from the lawsuit, have you noticed, you've been in the industry a while, the changes in the industry since the CFPB has come online?
So when I came into the industry, the CFPB was very new, and the whole industry was really focusing on the regulations, the compliance. I went to, like I said, a lot of industry events and conferences and listened to them, and I would advise clients and also change my own policies internally to make sure that we were being compliant. But at one point, and after I went through that first CID and it got enforced in the Southern District, I had industry people reach out to me that were doing studies, and you know, we were sharing some stories about how they operated behind the scenes like this. And it wasn't just my firm. It was, you know, I was being almost treated no differently than, you know, Chase Bank or any of the larger organizations. It really is a one-size-fits-all and not good for anybody, not Chase or myself. But with less money, being a smaller practice, you know, you do what you can to ward off an agency like that. But really what you do is you try to prevent it, like in any industry, and stay compliant. But when the rules are so blurred, like they are in debt collection, and there's just not a lot of hard lines, it gave them a lot of opportunity, I should say, to come in with their own set of rules and fine and kind of destroy a big part of our industry. A lot of the small players, I think, either went out of business or merged with larger ones because it became, I mean, my costs from the first year in business to the 5th year, prior even to the CID, tripled. The IT costs, the data costs, the protection costs. Not that they didn't exist prior, they just made it as if I was doing business like one of the large banks. There was a one-size-fits-all, and so I had to kind of take on additional IT, et cetera. So it certainly has changed the industry. Not for the better, though.
Yes, Mark?
Mike, Ron, I think, mentioned the Sailor Law case that's pending at the Supreme Court. Do I understand correctly that no matter how that case comes out, that your case can still go forward, that in particular the divestment problem or non-delegation doctrine problem with the case is independent of the ability to remove the director issue that the Supreme Court will be deciding in Sailor Law?
Yeah, that's a very good point. So Sailor Law is focusing on, as Mark said, the independent director removal for cause issue. While the Sailor Law filings, the petitioner in Sailor Law is arguing that the appropriations funding is unconstitutional. That's not really the crux of their argument. It's only related to a sort of general complaint about the Constitution or the lack of constitutional structure to the CFPB. We instead are taking that issue, that non-delegation issue, much more head on. It's such a peculiar setup to have the Fed just basically write a check for which no one else can review. This issue of Congress divesting itself of its appropriations authority is even more puzzling, given that to the extent that there are other organizations, because this is part of the CFPB's argument right now. As far as the funding issue is concerned, they give it's not really an argument, it's a logical fallacy of moral equivalency. They say, well, everybody's doing it. You know, and it's not everybody, but there are a few other government agencies that have this sort of peculiar receiving fees instead of getting direct appropriations annually from Congress, a more traditional what you'd expect. But the dynamic is entirely different in those circumstances. And so we're trying to directly confront that particular constitutional issue of Congress divesting itself of its responsibility. And it's far afield from the user fees that, say, National Park Service collects, or user fees that the Postal Service collect and put back into their system. And this is an enforcement agency that otherwise should be receiving funding in the lawful manner, which is the constitutional way to do this. And Sailor Law isn't directly addressing this issue, but we are. Yes, last question.
My recollection is in some of the prosecutorial abuse cases, maybe in the Duke case, I'm not sure if I'm remembering correctly, but couldn't you file for the fraud on the court, the attorneys that moved for mootness, couldn't you file a complaint with the bar and have their legal licenses revoked?
I'll let Ron chime in on this too. Maybe. I don't know. I didn't look at that issue for a very important reason. I don't know that it gets Crystal to where she needs to go. We need to make sure that we stop the CFPB's abusive process and get Crystal her day in court. So that was first and foremost. As much as I like the idea, it sounds exciting, and I wouldn't rule it out. I would be concerned that the court might view it as more retribution than really advancing the ball of Crystal's interest. But you bring up a good point. What, if I'm aware of this, what is my, as an attorney, and this is more of a CLE topic than it is maybe a luncheon law, but what is my ethical duty to report this to the bar? If I'm not going to go ahead and file a complaint, as you suggest maybe we could do, I mean, I might have an ethical duty to report it to the bar if I truly believe that that's what that they committed some sort of fraud on the client. Do you have anything?
Well, I can tell you, I serve on peer review panels in the state of Maryland for the Attorney Grievance Commission. I mean, that's not going to go anywhere. It's just, and frankly, the reason is the Bar Council look at it and say, look, you know, they're involved in pending litigation. I think it's highly improper, but then again, it's probably the modus operandi of the Consumer Financial Protection Bureau, with the tight deadlines, with the intractable positions that they take. In fact, my friend Manny Newberger, who has done a lot of this too, he says, when they get to court, they really don't have arguments. They have positions. But positions is not how you address a legal problem. The way you address a legal problem is through a legal analysis and referring to the statute, referring to the regulations, referring to the cases. Their focus is more generic. That is, you know, curing the system of people who try to get people to pay their bills. I mean, you know, that's probably too broad. But their focus is, you know, we're going to protect the consumers, and that's our mission. You know, the law is part of it, but not really the reason we're existing. We're existing because we have the power to do it. We have the power to, under Caudray, they had a regulation by enforcement policy, which I understand from reading materials on your website, the FCC does as well. That is, you don't really have any clear rules, so the way we're going to make rules is we're going to mete out punishment to the regulated entities. That just seems somewhat un-American.
And I think on that point, by trying to reopen the case, I know at least our conversations and our hope was that the judge would be upset by that, because it was pretty clear, especially when Ron found that manufactured mootness case, and it also was a Prescott decision. We thought for sure that he would be pretty upset. I mean, I know I've been before other federal judges that would not have handled it the same way. I think they would have been livid, especially since it was, like you said, a fraud on the court. I mean, there's really no other way to say it when 4 hours later they initiated the same exact action that we were before the court, when they just said that there was no jurisdiction because the matter had been moot. So I thought that the judge that day would take a harder stance. And I think in private practice, when I was litigating in the marine stuff, I would have been afraid to do that. I mean, you know, I don't think a government attorney would have maybe the same fear. I would never think in a million years that that would be a good idea. And would I feel comfortable going before a federal judge hours later doing that? It would never even cross my mind.
Crystal, I think this is a good closing thought for us today. I mean, you've said to me before, just if you had run your business the way the CFPB, how did you phrase that?
So the CFPB is preventing debt collection attorneys and debt collection agencies from bullying and harassing debtors to pay, right? I can't pick up the phone and say, if you don't pay today, I'm going to sue you tomorrow, or you know, this is going to go on your credit. I can't be aggressive like that. I can't give short timelines. They want you to be polite and respectful, right? And then what they do to their investigative targets, like myself, is give short deadlines, threaten suit, bully you, don't play by the rules. And I had said to Mike, if I collected debt for my clients and the creditors that I represent, the way they target and investigate me, I would have been out of business years ago. I would have never made it.
Great. Well, thank you, everyone, for coming today. We appreciate it very much. Thank you, Ron. Thank you, Crystal.